Now, I started out this trial by telling you all, and the judge just reiterated it, how every person has the duty to act reasonably to others. And I discussed earlier how this country, this great country that we all live in, there are laws and rules that we all share and we all must follow. And those are in place to protect innocent people like Cindy Deltoro from ending up dead due to the irresponsible actions of another person. Every person that goes out with a loaded firearm has the responsibility to the people of the community to act responsibly with that firearm. The actions, the choices that Alexander Deltoro made back in December of 2019 was not an accident. It was a choice for him to carry and take out his loaded firearm. It was a choice for him to point that loaded firearm with his finger on the trigger. And because of those choices, we all have been here listening to the evidence throughout the last week. And I want you to know, we did not charge Mr. Deltoro Jr. with first-degree murder, with second-degree murder. He is charged with manslaughter of a firearm because of those choices and those actions that he took. Now, there were several witnesses that were brought into you by the state to prove our case. I discussed how it was our job to prove this case to you through the witnesses and the testimony. And the first witness that you heard from, that was now Sergeant Richard Bravo Brown. He came in and he painted the scene. He's the one who we introduced crime scene photos through to you. And it's important to note that when he testified, he said that the first words out of the defendant's mouth when he arrived on scene were, "I accidentally shot my mom." Right then, the defendant says, "I shot my mom." And throughout then, we learned that Mr. Bravo Brown arrived onto the scene and told you all about what he saw. He told you how when he arrived, this is how Cindy Deltoro appeared to him. And yes, he did tell you that he rendered aid to Miss Deltoro, but that rendering aid was done only until first responders responded to the scene and pronounced her deceased. You heard through the testimony that although he was performing that aid, he did not think that there was a heartbeat. He was just performing that aid because at that point, she had not been declared deceased yet. He is not in the position to declare people deceased, and as his role as the first responding officer, he is to perform aid until that happens, which is what happened in this case. You also saw through Sergeant Bravo Brown the crime scene. We went through each of those markers that were labeled and what the significance of everything at each of those locations were. And that included the one shell casing that was found on scene that we later learned came from the defendant's firearm. Which Sergeant Bravo Brown told you he moved from the mulch area to this location and had it made safe, meaning it could no longer shoot, and it was placed there on the crime scene. Now, after you heard from Sergeant Bravo Brown, Lieutenant Coben came and took the stand. He was the lead detective at that time. And you have heard all about the experience that he has and how he handled the cases. You heard about that investigation, who they spoke to, where they tried to collect videos from, what interviews were done, what photographs was taken, what was sent to a lab. Everything that was done in the investigation of the case you heard from Detective Coben. You heard about the thorough search that was done from inside of that home, and how it was him and multiple different officers who were searching that home as a result of that search warrant. And you did hear that as a part of that search warrant, they were looking for additional items. They were looking to see if there were any other firearms or ammunition. And he testified that they did a thorough search. These are officers with close to possibly even over 50 years experience combined between just the three that you heard of. And these individuals were inside of the house doing the search, searching in all of these places, and there was only ever one firearm recovered, and that is the firearm that Mr. Deltoro Jr. admitted is the one that he accidentally shot his mom with. We also learned through Detective Coben the defendant's statement. And I want to go over with you different portions of his statement. This is something that you all will have the opportunity to take back there with you, along with most of the other items. I don't believe you get to take the firearm back there, but I believe everything else will get to go back there with you. And you will have the opportunity to listen to this in its entirety if you wish to. But there are some portions that I wanted to highlight to you while I have your attention now. Now, as you all remember, this interview starts out with the defendant entering the room, and he has read his statement of rights form that he signs, and you all have a copy of to go back there with you. It basically says he has the right to remain silent and refuse to answer questions. Anything he says can be used against him in a court of law. He has the right to speak to a lawyer before speaking to police and to have his lawyer present. If he decides to answer questions now without a lawyer, he still has a right to stop answering at any time. It goes on and on throughout there, and you have a copy of that. You have the actual form back there with you when you're deliberating. But I wanted to highlight to you about 9 minutes in.
On my back, and then I couldn't move because my dad beat it on me. I mean, he's 100 times stronger than me, like, there's no doubt about it.
Similar to the defendant's testimony today and last week, he reiterates and he tells the detectives, my dad is stronger than me, which is important to note a little later on. I also wanted to point out around 11 minutes and 28 seconds.
So my dad, really, honestly, obviously, I'm pretty sure you guys looked up his records and you've seen what, his past, well, I'm talking like 20, almost 25 last year, but I was born about 28 years, 30 years. He has a past, but
when the defendant tells law enforcement about the past that he was aware of and how it was about 28 to 30 years ago. Further on in the statement, around 1354.
Has he ever been physical with you before? Never. Okay. And you said that he's never laid a hand on your wallet. You're saying no, never.
This is just one of the times that detectives questioned Mr. Deltoro Jr., asking him if his dad has ever been physical with him before, or if his dad has ever been physical with his mom before. And this is the one of many times that he told the detectives that he has not been physical with them before. A little further on at 1429.
Well, he was basically just holding you against the wall. He's not hitting you or anything like that. Are you hitting your hand or anything? No, I couldn't. He had this hand, and then this hand was up against the wall, so that's when he had me like this, so I pulled my arm from it, because I can't do nothing like this, so he has me like this. So then that's when my mom came from this side, and she came in between us, and at that time I was pulling this out, and it just went all up.
This is one of the first times, or one of the many times, that he lets the detective know that his dad is stronger than him. His dad had him held in a position where he was unable to get out, but his mom comes over in the situation that was evolving. Later on, around 1630,
But you had full loaded, or it had 15 rounds and 14 rounds and one in the chamber.
so at that time, in the morning, around 2:23 a.m., this incident happened on October 14th. It's now in the morning hours on the 15th. He tells detectives that he was aware that his firearm holds 15 and that there was 14 in the magazine, 1 in the chamber. So on that night, when he took out that firearm and he had his finger on the trigger, he was well aware that there was a bullet in the chamber, that by pulling that trigger, that bullet will be ejected. Further on in the statement, around 1855, I'm going to play another portion for you.
was off, and that's when I was like, what the hell are you gonna do? And that's when I threw bottled water. I was already, because he was already pissed off at me, and I was already aggravated.
Where Mr. Del Toro Jr. admits that he was aggravated during this situation, that he did have aggravation towards his father throughout this situation, and this is in the very beginning that he's talking about when he throws that water bottle. I would like to highlight further into his statement around 2048.
The man is just ridiculously strong. What were you about that? My mom came running in between us and to stop us because that was when she came from that area, because then that's when we were being pushed from one area to the other, and we were just suffering. And that's when she came in between us, and at the time she was coming between us, where was your dad? Well, you told me you said you pulled him out. Yeah. Where was your dad at? Was he still around you, or was he facing away? At that time when he ran into Toro, I pushed, and he was in front of me because my mom came in between, so she got him off me basically. But it was like an extension. It wasn't even that.
And ladies and gentlemen, that's when you start to see what actually happened on that night. That's when it starts to slip from Mr. Del Toro Jr.'s mouth what actually happened that night. He said, when I pulled the gun out, my dad was in front of me, and then his mom came, and by that point, it was too late. It's right there, ladies and gentlemen, in his statement. On that night, he was aggravated with his father. He pulled a firearm on his father, and he ended up shooting his mother. I would like to highlight a little further into the statement around 2403.
See, I had to go get my glasses because my glasses fell off from the tussling. And I'm legally blind without these glasses. And
this is just one of the times that he mentions, and consistent with his testimony recently, is that he cannot see without those glasses. He is legally blind without those glasses. But still, without those glasses on, he pulled a firearm out. And originally, as I submit to you, he pulled that firearm out on his father, not realizing, because he couldn't see and because of what was happening, that his mother got in the middle of his aim, and that is how he ended up shooting his mother in the middle of her face. He describes a little bit further about needing the glasses around 2948.
I didn't have my glasses on, so obviously I couldn't see neither, so I didn't even know if my finger was in the way or not, and that's how, I'm guessing that's how it misfired.
And that's how it misfired. That's how the bullet that was intended for his father, or the gun that was taken out to intimidate his father, ended up in his mother's head. A little further on, about 5 minutes later, around 3327.
Nothing, that's my parents. I mean, I love my parents to death, so no, not at all.
Yeah, but the thing that doesn't set right with me, which is, if I'm pinned up against the wall, I'll put this in a holster. If I'm pinned up against the wall like this, and your dad and you were struggling as you demonstrated, and you're trying to remove a gun, if I'm trying to remove it, I can just simply pick it up, and if I'm worried about it, I can just drop it. I can either drop it, or if the problem is in front of me, you said your dad somehow got in front of you, along with your mom, according to your drawing. Somehow your mom is in front of you, and you're well, your dad. Your mom's kind of like here, and your dad's here. So if I take the gun out, and I'm like this, first of all, your dad broke away from you. At some point, your dad had to break away in close proximity as well as your mom. To where at that point, why even play with the gun? You could simply just stand up, or push off, or move, because your dad's there. I can pick it out and drop it. I can bring a weapon up and cant it in orientation up to where it's going to hit somebody in the face. You have to go from your holster here to some kind of degree of obviously breaking the plane of it trying to figure out. Did your dad piss you off enough? Because if he's already off of you and in front of you, why are we pulling out a firearm? Why are we worried about this? The discomfort this is causing is so minimal over the totality of it.
Really nothing you can do when you're at it. I was already playing with it to end the whole scuffle in the first place.
Yeah, you let go of it. That's all.
Exactly. Of course, I let go of it. That was the whole point. When it misfired, I didn't expect it to do that.
Or you want to shooting out of your waistband.
And it was too late. It happened all in an instant. You guys don't understand. When something's happening,
This is one of those instances, I'm assuming, where when Mr. Deltoro was testifying earlier, he said law enforcement is badgering him. That is not law enforcement badgering him. That is law enforcement calling out the story that he had on that night, that his firearm was pinching his holster, so he had to pull it out with his finger on the trigger at an angle that could shoot his mom. That's them saying, that doesn't make sense. Because, ladies and gentlemen, that's not what happened. He took that firearm out on that night because of his aggravation. That's officers investigating the case. That is not officers badgering Mr. Deltoro Jr. About 30 minutes later into the statement, around 36 minutes.
and she came and she pushed me off, and she pushed him off of me. I didn't go and get it before the hand. She pushed off, and as I was doing it, it was already too late because I already had it out. That's what I'm saying. And that's when it happened, and then that's when I dropped it at the same time. And like I said, I didn't have my glasses on, so I didn't see what was going on. I couldn't really see.
That's another time that a little bit of the truth of what actually happened comes out. It was too late. He couldn't see. He didn't have his glasses on. His mom was already in that spot. And a little bit further on, he starts to talk about how many times he's had that firearm and how many times he has shot that firearm to show that he knows exactly how to use that firearm.
Because at the same time, I can't see down here.
Let me ask you a question. You said you've had the gun for over 3 years. Correct? Is that what I would say?
Yeah, about 3 years. I would say about 3 years.
You've gone shooting before, correct?
Yeah.
Okay. Do you have a concealed weapons permit or no?
No.
Okay. How many times do you figure you shot that gun?
About 3 times, maybe about 3 times, maybe 4. About 3 or 4 times.
How much ammo did you go through when you shot those times?
About 50, maybe 100 rounds.
Each time, or?
Yeah, each time.
Okay, so somewhere around 300 to 500 rounds roughly over the 3 years you've had the gun?
Yeah.
Okay. Have you shot any guns other than that gun?
No.
Okay, so the first gun you ever owned or shot?
Sorry, when my friend came up here on vacation, he rented a gun and I shot the rented gun. Yeah.
Okay, but you've had that gun for approximately 3 years, shot anywhere between 300 to 500 rounds through it. How long have you had it?
So he goes on. He knows how that firearm works. He knows that with his finger on the trigger, that firearm is going to go off. Another time further into the statement, around 38:10, is another time that he says that his father has never laid hands on him and never laid hands on his mother.
Amount of time you even said so yourself before, your father's never laid hands on you, your father's never laid hands on your mom. He pinned you up against the wall. I understand he's really strong.
Nowhere at that time correcting detectives, well, actually he did, because that's what happened. His father did not touch him before. His father has not touched his mother before. And then the officers do some further investigating, or as the defendant would like to call it, badgering, around 41:10.
I mean, you can see, it's not comfortable.
I understand.
For somebody that tells me their father never laid a hand on them, tells their father never laid a hand on their mom, for this to escalate, or it escalated too?
I mean, my dad's obviously hit me when I was younger, but I mean...
No, but you're a grown man. Right, you're almost 30 years old, correct?
Yeah.
All right. You both are similar in stature. Yeah, your dad might be stronger per se, but you're not small by any means. All right. So we just have a very hard issue of trying to understand why nobody reaches when your face is plowed into the wall, your arms back, your only free hand is your gun hand, and you're trying to tell us. I was trying to remove it because I felt a pinch on my hip.
Well, I'm not only that. I mean, at the same time, obviously, I was aggravated, but I mean, I'm putting it off because I'm aggravated and
He was aggravated. Those were his words. Today when I questioned him, you were aggravated at your dad. You were aggravated in that situation. No. Those were not my words. Those were his words. He was aggravated throughout this situation with his dad. Another time that he uses that language is around 44:07.
After her, when we got out of the car, obviously, yes, I did get aggravated because I'm like, why are you going after her?
Once again, aggravated. His words, not mine. Around 45:28.
And she pulled us apart, and at that time I was already pulling out my gun, and that's when it went off as I was pulling it out.
Another time that the truth slips into his statement with the detectives in this case. And then at 48 minutes, another time that the detectives are badgering, in his words, Mr. Deltoro.
Gun came out. But your intention was to get the gun out.
Yeah, because it was aggravating me.
No, not the holster.
No.
Oh, because I got it out, yeah, because, the whole thing was pinching up against my side here.
No, I understand you're saying that, but from your story, when you're telling us, it just, I think it's,
You're making this little pinch sound out like it's something that was going to, like it's a big, the mark's not even there anymore. We all carry almost 20 years. It's a pinch, it's uncomfortable. It's not something that I'm getting my ass kicked or like you're claiming that your dad's overpowering, jamming your face, you broke your glasses. That's not your concern as far as pain or worry. Your concern is your dad's, like you said, he's got the best of you. You're pissed, you're frustrated, so you're gonna try to scare him.
it doesn't change anything. I just want to understand, because I feel like this whole thing will go back. That's all.
And detectives clarify with him, it doesn't change anything. We just want to understand what you are telling us. Further on into the interview, 59:10.
The intentional act, because now you said you were trying to do this, and that it was behind you. I had my hand behind me when I pulled it out, and that's when, obviously when I pulled it out, I had it behind me because my hand was like this, but when he let me go, that's how I was able to spin back around.
But exactly, he let you go. He was no longer behind you or holding you. Even the little diagram that you drew didn't show that your mom was kind of off to your left, and your dad's more
Yeah, she got in between us.
Yes, so that's where we're coming to say you were going to use the weapon as a way to intimidate your father in a discharge.
It's kind of like these detectives know what they're doing with the questions. It's kind of like their experience is coming into play. A little further, an hour, 2 minutes, and 13 seconds.
Is that's an intentional act, bringing your hand from behind your back forward, especially when you have a firearm in your hand. You're smart enough to know, I got a gun in my hand. You've been trying to get this gun in your hand the entire time, or at least remove it. We can debate the facts of it, but for the mindset of it, all right, we can debate that. But you're well aware that gun is in your right hand, okay? They come from behind you to forward in that type of angle to where your mom got struck in the face. Bringing it forward is an intentional act. You know it's in your hand. The discharge part we can agree is an accident. Because I don't think you meant to shoot your mom. Okay? I think, and we both think, you meant to intimidate your dad to get him maybe away from you. Or put fear in him or something, and it went off on an accident.
And once again, ladies and gentlemen, just like it was discussed during jury selection, law enforcement officers, they are like any other witness. And they are to start out, when it comes to credibility, on the same playing field as any other witness. Until they take the stand and testify, and then just like any other witness, you get to take into consideration their experience, their training, everything that they have gone through in determining the credibility of them and their testimony and what they did in this case. And the last thing I would like to point out, once again reminding you, you will have this full interview to go back there with you if you wish to play it again, is around 1 hour, 9 minutes, and 28 seconds.
Glasses. Does you get a second pair in the car? put anything else away in the car? There wasn't a second firearm in play?
No.
Or did your dad have a firearm?
No.
Or did your mom have a firearm?
No, I said she had. She's had one in the past.
All right.
No.
Okay. No, so nobody else pulled a firearm. You and your dad didn't wrestle over the firearm?
No.
Okay.
Is him given the opportunity and stating one more time, there was no second firearm. His dad did not have a firearm. His mom had a firearm in the past. Him and his dad were not wrestling over his firearm. And the conclusion is that it was his firearm and only his firearm involved in this case. Now, after we heard from those two witnesses, you had the opportunity to hear from the medical examiner, Stephen Robinson, in this case. And through Mr. Robinson, Dr. Robinson, additional evidence was entered in this case. At that time, you learned that there was one projectile recovered from Ms. Deltoro's head. In the previous photographs, you could see that this is the entrance wound on her face. He discussed the various stippling, those little black dots that you see on her face, and how that is how he was able to determine that the gunshot was within intermediate range, basically not too close, not too far. And then further through his testimony, you learned that that projectile traveled from the front of her face, ended up back here, in the back of her head. That was removed and collected as a part of the investigation in this case. What you learned from Dr. Robinson with his extensive experience is that the cause of death in this case was the gunshot wound to the head, and the manner of death in this case was homicide. And then the final witness that you heard from in this case from the state was the firearms expert William Ruiz Fontanez, who works at the Broward County Crime Lab. And you learned through his testimony that the firearm that was collected in this case, the one that was photographed from the scene, the only firearm involved in this case, the only firearm that a bullet was released from in this case, and the firearm responsible for ending Cindy Deltoro's life was collected and compared to the shell casing found on scene that I highlighted in the photographs, and that the results were that this shell casing came from this firearm that Mr. Deltoro admitted was his and that he shot that night. You also heard from Mr. Ruiz Fontanez that that firearm was operable, that there were multiple safeties in place on that firearm, including the trigger pull safety, and that all of those safeties were working as they should on that night. Meaning, without the defendant's finger on the trigger and pulling that trigger that you learned from him requires 6 pounds, that firearm was not going to go off, a bullet would not be released from that firearm, and it would have not entered Cindy Deltoro's head. Then there were a few defense witnesses in this case. You heard from Sergeant Schwartz. Sergeant Schwartz did everything with Lieutenant Coben. There's nothing additional there. They did the search together. He told you that he searched his portions thoroughly. They did the interview together, as you see in evidence. He was there on the crime scene. So where the state presented to you the lead detective, defense brought you the other detective Schwartz to tell you everything that Coben had already said. But instead of Coben looking in his parts, Schwartz looked in his parts of the house. He was present for the interview. He was on the crime scene. Same thing with Dakota Dunn, where the state introduced to you, I'm not going to play it, about a 9-minute video that Dakota Dunn did of the crime scene, as well as the photographs that I showed you some of from the crime scene. Instead of putting her on the stand, the state called Lieutenant Coben, who got all of that in. The defense called CSI Dunn to say, yeah, that was me. I did the video. I took those photographs. She tells you that she was present when the home was being searched. Although she was not the one searching every area of the home, she was present for it. She photographed the home. She photographed different items that were collected, and she did that body-worn camera of the walkthrough of the scene. And then finally, David Glatter, the other firearms individual in this case, also works at the Broward Sheriff's Office Crime Lab. also testified on Zoom, did everything that William Ruiz Fontanez did, although Fontanez took it one step further to compare the casing to the firearm. You heard a second time from a second firearms guy that the firearms was operable, all safeties were in place, including that trigger pull, and without a finger on that trigger pulling 6 pounds, that firearm is not going off, a bullet would not be released from it, and would not end up in Cindy Deltoro's head. Then you heard from the defendant himself, who now, 5 years later, argues self-defense. After he gave over an hour and a half, or about an hour and a half statement to detectives on that night, after he told law enforcement that night immediately, I accidentally shot my mom, now, 5 years later, is arguing self-defense. Now, 5 years later, is presenting you with some broken eyeglasses. When Mr. Deltoro Jr. took that stand, he was well aware of all of the other evidence that was testified to. He sat there, he paid attention to what was said, what was presented. His father had not testified, so now it's the blame game. He's not here, I'm going to blame my dad for everything. And ladies and gentlemen, it's important when going through the evidence in this case that you stay on Main Street and you look at the elements that the state has to prove, and I submit to you we have proven of the manslaughter with the firearm, and do not go down a side street. But I want to go through a few things with you so that you feel comfortable doing that. The dad's testimony is going down different side streets. The testimony about the dad who now pushed his mom, who is this frail woman who is undergoing cancer treatment, stage 4, not being given all of her appropriate medication because his dad is a pill head who likes to take his mom's medication, in addition to now, 5 years later, being controlling, being manipulative, being a lowlife, being broke, not doing pretty much anything, being a bad dad. Now is when he wants to say that through all of that, his mom was able to get up and shove his dad, even though just prior to that, he still remains consistent that his glasses were not on, the glasses that defense counsel gave each of you to look through, the glasses that he admitted he cannot drive without because he cannot see signs. He then says that without those glasses, he was still able to see that his dad shoved his mom gets up and shoves his dad, and then his dad takes something out of his pocket that he is having you all guess was a firearm. Having you speculate, imagine, force in your mind is a firearm, because there's absolutely no evidence that that was a firearm. But regardless, his testimony is to have you speculate, imagine, and force that that is a firearm in your mind. Even though his own testimony is that he carries a firearm, but he likes to put his in his car's glove compartment when it's not on his body. But in this case, he wants you to believe that his dad never did that. His dad 24/7 had one of these million firearms that he's not supposed to have on his body. And that at no point in time did that firearm ever come off of his body, because he wants you to think that without those glasses that he is legally blind without, he saw his dad take out a firearm. He is guessing that that is what it was, if you even believe that version of events 5 years later, as he is trying to get a self-defense instruction in front of all of you. The law is designed for situations just like that. Somebody cannot guess that another individual has a firearm in their pocket and takes it out, so then now they get to take out their firearm and shoot it. That is an irresponsible gun owner. That is not somebody who is looking out for the people of the community. That is somebody who was aggravated and who saw an opportunity to take out that aggravation on the man that he disliked so much in a moment that he could try to justify it. And that's only if you believe that version. And that's only if you believe that there was a firearm. I submit to you that there wasn't. and there is no evidence of that. But even if you were to go down a side street, you can make a U-turn and make it right back to Main Street because he never even saw a firearm. And for there to be any evidence now of that would not be truthful because the evidence that came out was that he could not see, and it was something that he thought could have been his dad's firearm. However, in that version of the firearm that he shot 300 to 500 times that was working properly, he took out that firearm that he knew was loaded. He carried that firearm over to the situation after he threw the water bottle at his dad. So before he got out of that car, he made the choice to get it from his glove compartment and take it over to his dad, who was already aggravating him, who he then threw a water bottle out, takes it out, points it with his finger on the trigger that he knows is working as intended, and he then shoots that firearm, misses his dad, and hits his mom. And that's in the version that we just heard from him 5 years later when he's trying to get self-defense. That is the version that he has changed. That is the story that he has had this time to come up with and that he has now put in front of all of you. There was one more witness, the defendant's aunt. The aunt who you can determine her credibility. It is your job to determine credibility. This is the aunt who obviously was going to say whatever it took to protect her nephew, who obviously did not like her brother-in-law, who loved her nephew, hated guns, didn't even know what he was in jail for, but who got up there and said everything that she was told or heard to say. She was not there for this incident. Her testimony is not relevant for this incident because she was not there, so why was she called? She can't add anything to what happened on that night because she didn't see it. So why was she called? You are the ones who can determine her credibility. Now, the judge just read to you the law in this case, and there is some of the law that I want to go over. Now, the judge just read to you this instruction, and you will have a copy to go back there with you, so you don't have to worry about writing down every word. But this is the introduction to homicide. Alexander Deltoro Jr. is accused of manslaughter with a firearm as charged in the information. Manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Cindy Deltoro was killed by Alexander Deltoro Jr., you will then consider the circumstances surrounding the killing in deciding if the killing was a manslaughter with a firearm or whether the killing was excusable or resulted from justifiable use of deadly force. It then defines justifiable homicide for you. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting any attempt to murder or commit a felony upon the defendant or to commit a felony in any dwelling, house in which the defendant was at the time of the killing. This is why the defendant has taken this 5 years to come up with the story to testify in front of you. Trying to have you think that it was justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony. But there's no evidence that that was done. There is no evidence that his father tried to commit any felony. So it's important to take that into consideration when listening to the arguments here and following the law in this case. The second portion of that page is excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Number one, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Well, it's not an excusable homicide here because there was no lawful act by lawful means with usual ordinary caution. It is not usual ordinary caution to take out a loaded firearm and put your finger on the trigger. There is nothing lawful about what Mr. Alexander Deltoro Jr. did in this case, and therefore that does not apply. The second option, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. So let's look at the first one. There's definitely no accident or misfortune in the heat of passion with the version that he gave law enforcement on that night. Because the version that he gave law enforcement on that night, there's no heat of passion. He took that firearm out because it was pinching him. He took that firearm out and tossed it, and it popped, which we heard is impossible to have happened based on the way that the firearm was functioning. So then what do we have? What he's thought of for the last 5 years to try to get certain things put in front of you. The heat of passion, there was no heat of passion in his statement as it stands in the last today and Friday, because you would have to find that credible. You would have to find that what he said was said to be truthful and what actually happened. There was no heat of passion in this case. The defendant's dad did not take out a firearm in this case. At most, he pinned him up against a wall. That does not warrant a firearm being taken out and pointed in his direction that he knows is loaded. And the last option, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Clearly that does not apply because a dangerous weapon was used, which is the firearm in this case. As the judge read to you, you will get the full instruction for manslaughter. In order for the state to prove the crime of manslaughter, we must prove the following two elements beyond a reasonable doubt. That Cindy Deltoro is dead, which was stipulated to by both parties as well as testified through Dr. Robinson. And two, Alexander Deltoro Jr. intentionally committed an act or acts that caused the death of Cindy Deltoro, or, so one or the other, A or B, the death of Cindy Deltoro was caused by the culpable negligence of Alexander Deltoro. That is where it comes into place what I have told you throughout this trial. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide, as I previously went through with each of you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. So he did not have to have the intent to cause death, no first degree, no second degree murder, manslaughter, that he had, even though he did not have to have the intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. The law then defines culpable negligence to you, which states, every person has a duty to act responsibly towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant, taking out a loaded firearm and putting your finger on the trigger. Culpable negligence is a course of conduct showing reckless disregard of human life, taking out a loaded firearm, or of the safety of persons exposed to its dangerous effects, introducing a loaded firearm to an argument, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, taking out a loaded firearm during an argument, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. This is what I am talking about, where these laws that we all must follow are designed to protect what happened in this case, to protect innocent people from being in the wrong place at the wrong time and having the effect of an irresponsible person's actions, of their culpable negligence by taking out a firearm that they know is loaded because they loaded, either had one in the chambers or they racked on scene, whichever version we're going to go with, took that firearm out and pointed it in the direction of another human being and eventually pulling that trigger, or that trigger being pulled because it was introduced in that situation. That is culpable negligence. That is reckless and wanton disregard for human life, for safety. That is manslaughter with a firearm. You're also going to receive an instruction for the aggravation of a felony by carrying a firearm, which basically says that if you find that the defendant committed a manslaughter and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, or used a firearm, you should find him guilty of manslaughter with a firearm. So it is the additional factor of not just being manslaughter in any other way, a punch, a knife, a car. This is manslaughter with a firearm, so you find that he used a firearm in this case. And then we have the instruction which caused Mr. Deltoro, before I get to that one, there's one more. Transferred intent. Because you might be thinking, well, is it manslaughter with the firearm if his mom is the one who ended up dead? Transferred intent is that if a person intends to hit, strike, or shoot a person, and in the process hits, strikes, or shoots a different person, the law transfers the intent to hit, strike, or shoot the intended person to any person who is actually hit, struck, or shot. Which basically says that he can be guilty of manslaughter with the firearm with his mother as the victim, even though she was not the intended target in this case. She was not the one that he intended to intimidate, or he intended to fear, or he intended to kill, but she is the one who, as a result of that transferred intent towards his father, ended up dead in this case. And now we get to the instruction that caused Mr. Deltoro to have 5 years to now come up with a different story in front of all of you so that he can get this instruction, justifiable use or threatened use of deadly force, where he would, under the original facts that he told, this obviously would not apply, but under the testimony that he has given us in the last 2 days, this instruction is here. It is a defense to the crime of manslaughter firearm if the actions of Alexander Deltoro Jr. constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm, it's obviously distinguished from other types of harm. In this case, somebody ended up dead, so obviously it's great bodily harm. Alexander Deltoro Jr. does not have the burden of proving that he was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law of the justifiable use of deadly force is as follows. Alexander Deltoro, is it frozen? Okay. Alexander Deltoro Jr. was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or another, or, so one or the other again, similar to manslaughter, the imminent commission of an attempted murder or aggravated assault against himself or another. It further states, basically, that you could consider the circumstances at the time the force was used. So let's focus on these two. He was justified in using deadly force if he reasonably believed that such force was necessarily to prevent imminent death or great bodily harm to himself or another, or the commission of an attempted murder or an aggravated assault against himself or another. Well, obviously, the statement that he told law enforcement back in December of 2019 does not meet that. There is no evidence that there was any imminent death or great bodily harm because somebody's feelings were hurt because they got elbowed in the head and started yelling and slamming doors that he says was so hard that glass could break. There was no broken glass here. So there's no imminent death or great bodily harm in the version that he told cops back in December of 2019. Even when he was pinned up against the wall, no imminent death or great bodily harm. There was no mention of a firearm back then, nothing. Or the imminent commission of attempted murder or aggravated assault against him or another. Being pinned up against the wall, yelling, screaming, slamming doors does not qualify as attempted murder, or aggravated assault. So neither of those apply in that statement that he gave law enforcement back in 2019. Now let's look at the statement that he told all of you today and last week. imminent death or great bodily harm to himself or another? Well, through his testimony, once again, he still is not saying and cannot say that there was a second firearm. He's just guessing that something else was taken out of his dad's pocket. He has had time to think of this story to say that something was taken out of his dad's pocket. There is no evidence of imminent death or great bodily harm. Even in his version, someone being shoved, someone's hair being pulled, does not qualify for imminent death or great bodily harm that then allows somebody to take out a loaded firearm. Or the second one, the imminent commission of an attempted murder, aggravated assault against him or another. Once again, there is no credible evidence in this case to that. There is nothing that is going to corroborate his version of events that there was a second firearm that could have created an aggravated assault or an attempted murder. I just have a couple more jury instructions to go over. It's going to freeze again. Okay. This one is the plea of not guilty, reasonable doubt, and burden of proof. And this discusses, as we did in jury selection and the judge read to you, whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And as stated earlier, just because somebody takes the stand and says something, you are to determine the credibility. So defense counsel in jury selection was discussing how a reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. This is evidence on Main Street. This is evidence on those elements that I put up there with you for manslaughter with a firearm. Not going down one of these side streets, but staying on Main Street of manslaughter with the firearm, and it's evidence that you find credible. So just because one person takes the stand and says the sky is blue, and another person takes the stand and says the sky is red, does not mean that there is a conflict in the evidence if you don't find that evidence credible regarding the sky being red. And that is something for you to consider when you are staying on Main Street with the elements in this case. You're going to receive, and the judge read to you, the instruction for weighing the evidence. And once again, it is up to you to decide which evidence is reliable. And you should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. And it specifically tells you in considering witness evidence that you should consider how the... It's frozen again, whatever. You should consider how the witness acted as well as what they said. Some things that you should consider. So this is important with witness testimony. Did the witness seem to have an opportunity to see, with their good vision, see and know the things about which the witness testified? So Pamela De Silva, see, no, nothing as it relates to the manslaughter with the firearm. Mr. Deltoro Jr. with his vision that he can't see without his glasses, nothing to do with that. But did the witness seem to have an opportunity to see and know the things about which the witness testified? When witnesses told you what they experienced, saw, heard, collected, photographed, all of that, did they have the opportunity to see and know those things? Did the witness seem to have an accurate memory? Were they saying, I don't know, I'm not sure, I don't remember? And if they were, was it something that would make sense, that you can use your common sense that 5 years later somebody wouldn't know, not remember, or not know? Was the witness honest and straightforward in answering the attorney's questions? Or did they go down a side street instead of staying on Main Street? Did the witness have some interest in how the case should be decided? Well, obviously, Mr. 5 year later testimony, the defendant has an interest in how the case should be decided, has the most interest in how the case should be decided, and that is something that you can consider, and the law has told you you should consider when weighing his testimony. Does the witness's testimony agree with the other testimony and other evidence in the case? One more time. Does the witness's testimony agree with the other testimony and other evidence in the case? So you are to look at the evidence that was presented, the testimony that came in, and see which testimony and which evidence all goes together. I would submit to you that it is as the state has presented it to you. And that when you take away Mr. Deltoro's evidence that you are to determine if it's credible or not, the evidence fits. That this is what happened because of his actions and his choices on that night. And then finally, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? So obviously you can consider the two statements made by the defendant in this case. And you can take into consideration why he would have gave two different versions, and you can take into consideration which, if any, of the versions you want to consider, and what part, if any, of those versions you would like to consider. And in doing that, there is a verdict form that you will get back there. And that verdict form has two options. The defendant is guilty of manslaughter with a firearm, charged in the information, and the defendant is not guilty. I submit to you that because the state has done its job in this case and proven to you those elements for manslaughter with the firearm, staying on Main Street, the state has done its job, and you can check that first box. The defendant is guilty of manslaughter with a firearm as charged in the information. And then, if you find the defendant guilty, you must answer the one question that is on there. During the course of the crime committed, the defendant, Alexander Deltoro Jr., actually possessed a firearm, yes or no? I think all the evidence in this case, including his own testimony, is that he actually possessed a firearm, but that's the reason why I read you that additional instruction is for that question there, and I feel like you can feel confident and comfortable in checking yes. And before I sit down for defense counsel to get up here, there are rules for deliberation that the judge will read to you. And it's important to note that it states in there, the law is there for you to consider, that this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. It is sad. It is sad what happened in this case. Cindy Deltoro did not need her life to end. Her life should not have ended because of the actions of other people, the irresponsible actions of somebody else. It is sad. And it is sad that it was done by her son. But that is not something that you are to consider and that the law tells you you cannot consider when rendering your verdict in this case. That it cannot be decided because you feel sorry for anyone. That he cannot get a free pass because you feel bad for him, that it was his mom. It is sad. It is sad when you take out a gun and mean to shoot or scare your dad and your mom ends up dead. But that is not something that because you feel bad, you can consider. You cannot. That is what the law says here. And in addition, it says your verdict should not be influenced by feelings of prejudice, bias, or sympathy. So it's that important, it's in there twice. It says your verdict must be based on the evidence and on the law contained in these instructions. And ladies and gentlemen, I am confident that the state has done its job and that you have listened to the evidence and that you have listened to the law. And when you follow the law in this case, you should feel comfortable and confident because the state has done its job in holding the defendant accountable, in there being justice, and find the defendant guilty as charged of manslaughter with a firearm. Thank you.
Good evening. As you go home tonight and many times the rest of your life, you're going to retry this case. You're going to think of it one night when you're in bed, maybe when you're having coffee, when you're driving to work, thoughts of it are going to cross your mind. As you go through life, more than likely two things are going to pop into your mind. When and how is Junior doing, and did I do the right thing? We can't look into your minds and your hearts, But when you told us that the arrest wasn't going to be considered as evidence, we believed you. When you said you wouldn't convict on speculation, we believed you. We're going to take the word of a police officer over someone else, or you said that Junior was innocent of this terrible tragedy unless and until the state proved him guilty beyond a reasonable doubt. We believe you, and Junior doesn't have to prove anything. We proved a lot, but he didn't have to. When you assured us that you weren't going to convict on suspicion, suspicious circumstances, hunches, intuition, or speculation, we believed you. When we asked if you would hold the state to the requirements of proving Junior guilty beyond and to the exclusion of every reasonable doubt, we believed you. The state has so far not proven anything in this case, much less beyond a reasonable doubt. Let's go through first the witnesses. And I'll pick out the things that I think were important to think about. Sergeant Bravo Brown. He said he came onto the scene and Junior was frantic on 911. He tried to render aid. We know that his mom was still breathing at that time. He told you that Senior was never once near his dying wife, and didn't even know that she was dying, but wasn't near her ever. Junior spontaneously stated, "I accidentally shot my mother." Nothing wrong with that. It's pretty much true. It was his gun. It went off. It was an accident. But it's the why and the how. That's the big part of this that no one seems to be talking about. What was Senior's response to Sergeant Bravo Brown? "I don't know what happened." Okay. Senior didn't want to give a statement. Okay. He knew they'd be inconsistent. Okay. And Senior didn't show any emotion. I think those are pretty important facts. The second witness was Lieutenant Sean Coleman. He was one of the two detectives, obviously, that was there. Now, he talks to Senior, and what's the first thing Senior says? "I was over at the dumpster."
Objection, Your Honor. Facts not in evidence.
What?
Overruled.
Over at the dumpster, heard a shot, ran over, and said, "What happened?" That's why the detective said that they looked in the dumpster to see what was in there. We didn't hear that they didn't find anything in there because he wasn't there. We know that Senior said there was no confrontation. Okay, well, that's consistent with him being at the dumpster. We know there was at least another version, whether Senior was in the house and heard the shot, but once again, nowhere near Junior or his wife. So what does he do? The crime scene investigator's there, and he directs her to go do the blue clue, which is what the Margate Police Department used. I'm not discrediting a gunshot residue test. He orders the crime scene investigator to do a gunshot residue test to determine if Senior was close enough in proximity to Junior within 2 to 3 feet to see if he had gunshot residue. That he uses for his investigation at the scene. Now, he said that crime scene investigator Dunn should have sent it to the lab, but ultimately it fell onto his responsibility since he was the lead investigator. CSI Dunn had said that she also took the clothing because, let's say there was dissipation of the gunshot residue, that the clothing or the other test that she did, that they still have the evidence over at Margate Police, was never submitted to anywhere. That's lack of evidence. So we're left with a gunshot residue, 2 tests that were done, and nothing was sent for confirmation. So you're left with, okay, what would that have shown? He told you that he listened to the 911 tape. He told the prosecutor, and that it lasted about a minute. Now, I submit to you, there is no way that Junior called 911 and Sergeant Bravo Brown was there when the 911 operator said, okay, you can hang up now. Then I asked him, wait a minute, why isn't you listening to this 911 call in anywhere in your reports? I don't know. Why I took your deposition, however long, certainly years ago, when I asked you that same question, you didn't recall ever listening to the 911 tape. But now all of a sudden, something triggered his memory that, oh, I listened to it and it was about a minute. Okay? State always plays these for you. I mean, I don't know too many trials where we deal with a situation like this where 911, that wasn't the only 911 call. Rest assured, this is an apartment complex. This is 10:30 at night. There's so we don't know how many 911 calls there were. And we know that, so he doesn't do the gunshot residue test or send it for confirmation, either of them. And now we have lost or misplaced 911 calls. That would let you listen to exactly what was going on, what he's saying, his demeanor, his voice inflection, what he's seeing. We don't know, and I'm sure, well, we'll never know what's on those 911 tapes. Then we got into Senior's priors. Senior is this mythical person. Okay, you guys, we have to piece together what he may have said. Regarding his priors, Sergeant Coben said there was no need to check him for priors. And then he said, why would we do that? Gee, I don't know. I asked him, how long would it take you to run them for priors? He said, 5 to 10 minutes. It's just a teletype. I said, you could do it right now then. You could do it during a break. Wasn't done. Why? You had Sergeant Schwartz, Detective Sergeant Schwartz now, who said, yeah, that's normally done. It should have been done. I don't know why it wasn't done. That's conflict in the evidence. And, I mean, just, okay, let's say, for whatever reason, they didn't think about it. You had Junior told him, I'm sure you guys looked up his record, his past, and you would think something would go off. Maybe we ought to see, because that could be used in our investigation. I mean, they didn't know what they had. But they knew they had enough before they even got to the police station. They knew they had enough to charge Junior. That was made clear. Sergeant Schwartz said, negligence, resulting death, you held the gun, that's enough. Okay, that's why we're here. Said nothing about culpable negligence or anything else. But we'll get into that. I asked Lieutenant Coben, possession of a firearm by a convicted felon, is that a serious crime? Yes. Okay. And now I asked him about the arrest. I said, other than Senior and Junior's version, did you have anything else? Any other evidence at all? No. Exclusive of their statements, we had nothing else. Then I asked them, okay, we had a situation where Junior was in the vehicle. They came back from celebrating his birthday. They knew that there was no prior altercation physical, certainly not by Junior against Senior. Testimony was that Junior was moving his arm to avoid the vehicle next to him, and he accidentally hit his father, who was actually, for a change, in a decent mood, bebopping to the music, and they were 2 minutes from their house. Junior immediately apologized. This is all known to him. So all that's known to him. And then 2 days later, Lieutenant Coben adds another charge on to Junior for domestic violence battery. Okay? And what did he say? He had no problem with Senior's credibility. Which means that Junior, for the first time in his whole life, on his birthday, going home, trying to avoid an accident, he just cold cocks his father. Doubtful. Junior immediately apologizes. There are two decent, certainly Junior's a big guy, two decent-sized guys in a small Mitsubishi Mirage. And this couldn't have been an accident. They had no problem with Senior's credibility that Junior cold-cocked them. And what did he say? I didn't see why Senior would lie about something like that when there's a bigger issue. Okay, well, he lied about that. He lied about the dumpster. He lied about where he was. You did a gunshot, two gunshot residue test. Okay, but we don't have a problem with his credibility, and all that is known. But yet, 2 days later, he throws on another charge of domestic violence against him. And on top of it, he admitted that Senior said, Junior, you're lucky, because in my younger days, you know what I would have done in my younger days? Okay. What are we dealing with here? You'll never know. Then, on cross-examination, the prosecutor gets out of him. Yeah, he gave several versions, but he gave several versions to protect Junior. Okay, so let's think about this. The versions that he gave that would have protected him basically has Senior far away from the incident, which means that Junior took out his gun and just shot his mother. That's what that means. So how could those versions be there to protect Junior? We'll talk about the search with Sergeant Coben. I submit to you it was not the thorough search that the state's making it out to be. I mean, did you pat down the clothes? Okay, that's kind of something basic, you know. If you were looking for a firearm, let's check the clothes, let's check the boxes. I mean, there's plenty of, you can see the pictures, there's plenty of clothes, plenty of boxes. but they didn't pat down the clothes. He believes they looked in all the drawers. Now, why did they do the search of the house? Because immediately after the shooting, instead of going to your dying wife, you go back to behind the car, you pick up her pocketbooks, Junior's glasses, and the chains. And then you go into the house and you disappear for a couple minutes. So they think that, well, maybe we better search the house. But we're going to mainly concentrate on the kitchen because that's where the pocketbooks were. I submit to you, that's the last place you should look. Why are you going to look right where the obvious place is? You're not going to find anything there. Let's look in the other rooms. Or the other. And what was his justification for not going into this further? When I asked him about pursuing Senior's action of being more concerned with going into the house versus going to his wife, what did he say? People react differently. You want to be married to them? Can you envision people reacting differently or that way and it being normal? I asked him whether he took a statement 2 days later, which would have been after the next morning, with the neighbor Lampley. Did you talk about Senior leaving the residence while you talked to her about prior to giving her statement? Not sure. Asked him whether he ever spoke to Pam De Silva and Virginia De Silva, Cindy's sister and mom, that were with them. His granny was with them the entire evening, and his Aunt Pam was with them periodically, but certainly within 15 minutes prior to this happening. I mean, the state's saying this thorough investigation. I mean, maybe I'm wrong. Asked him about Junior statement at the scene as well as what you all saw. And he said that he believed them up until the point of pulling the gun. I asked him whether he believed that his arm was twisted. Yeah, it probably happened. I asked him whether he believed that the glasses were broken off. Yeah, probably happened. Asked him about pulling of the hair. Yeah. Asked him about the chains breaking. How are you going to find a pendant? You're not going to find a pendant on the ground unless a chain broke it off. It came off of the chain. That's just one. Asked him if he believed that Junior was pushed up against the wall. Yes. I asked him, did Junior give you the impression of being hot-headed? Because that's what we're, in these type of cases, I mean, if someone's hot-headed and maybe you can see something, but said, no, it didn't give me an impression of being a hot-headed person. I said, did he seem to be truthful? For the most part, up until the point of pulling of the gun. And what was he saying about the pulling of the gun? That it didn't make sense. You got these two detectives that are drilling a person that had never been in trouble before, that had never even gotten a ticket before, being left down for 2 hours, being watched by another cop, knowing that your mother is being gravely injured. You don't know what has happened to her. You're unsure. You just know that whatever it is, it's horrific. You have him thinking, my God, what do I tell the police? What do I tell the police? If his mother makes it and he throws his father under the bus by telling the truth, and then Cindy gets upset with him because her husband's back in prison. Or she doesn't make it, and then he's thinking, I always promised my mom because she wanted me to look out for my dad if anything ever happened to her. Can you imagine what was going through his mind? And then he's being taken to an interrogation room for the first time. All these things going on. And the prosecutor points out the word aggravated like 12 times or 10 times in the statement, and that's what they're basing their whole case on. Aggravated, aggravated. I was aggravated. Why were you aggravated? He was up in my mom's face. He was pushing my mom. He chest bumped my mom. He started to say push, and this whole case boils down to the state talking about these little snippets that they can pull out of this interrogation. I mean, it's not like on his best day that two detectives that have all these years of experience can't trip someone up. And what do they trip them up on? The pulling of the gun. It doesn't make sense. Why doesn't it make sense? Well, I told you in the opening our theory of the case, and I think we showed that our theory of the case is the only thing that makes sense. To this day, prior to them testifying, they had no clue how this happened or why it happened. Why and how. Those are the two big things that seem to be just dissipate in the air. And what was Junior saying in this statement? Well, let's pull out some of the other things that he said. I don't like when he's rowdy with my mom. He was really in her face. He was pissed at her. She was saying, his mom was saying, "Why are you upset with me? I didn't do anything. I got your bag." His bag didn't have his keys in there. So let's look at his statement with a different eye than just this word aggravated. Junior said, "Mom had nothing to do with it. It was a mistake. I didn't mean to. I apologized." And the lieutenant admitted that Senior said that he called Junior and asked and pushed him. Senior's statement's critical. Senior's actually critical. Well, there's the judge has already read you, as well as the prosecutor, weighing the credibility of witnesses. So let's weigh Senior's credibility through the eyes of one of the two lead detectives. Was Senior forthright in answering his questions? Well, you can't give multiple versions and be forthright. Did he seem to have an accurate memory? No, that definitely didn't happen. Was what he said consistent with other evidence? Well, no, that wouldn't have happened. Did he have an interest in the outcome of the case? Well, at the very least, possession of a firearm by a convicted felon is very serious. If it was proved what he actually did, I submit to you, Junior wouldn't be over there. It'd be Senior. He was asked 2 times. He asked Senior, "Did you see a gun in his hand?" Why'd you ask him 2 times? 2 different answers. You either saw the gun or you didn't see the gun. And then, that insult to injury at the end of the statement, he tells Senior, "Well, we'll escort you downstairs real quick. Talk to your son just to get his version. Bear with us. We appreciate it. Then we'll have an option to take you home and take care of you." Okay. Mr. Ruiz Fontanez. He said a couple things that I had no problems with. He said the nitrates from the gun that creates a gunshot residue go out 2 to 3 feet. Okay? No problem with that. The other point the prosecutor brought out from him, if your gun is pointed at the ground and it's fired, where will the bullet go? We don't have a problem with that. The bullet's going to go in the ground. Okay? And the other thing that he said, a gun is not going to get fired unless the trigger is pulled. Okay, we'll go along with that too. David Glatter, the firearms person that we called from the same department, works for Broward County Sheriff's Office. He said that, consistent with the last gentleman, that because the gun's not perfectly sealed, the gunshot particles go out of the muzzle in a cone shape, about 2 to 3 feet, consistent. If the shooter's back if your back is to the shooter, would you expect there to be gunshot residue on the front of his body? No. So then we had the prosecutor discredit the blue clue gunshot residue test that the state's law enforcement agency uses on all their shooting cases. Okay, he hadn't heard of that test. So that discredits it. No? He says, well, I really don't know. The important thing of his testimony, the most important, which is why we called him as a witness. If your finger is on the trigger and someone comes up and just hits your hand, can that cause you, the person, to accidentally fire? Yes, if it's bumped, if it's slapped, hit, or jolted. It would discharge because the gun would think that you meant to pull the trigger. Where is the gun going to discharge? Wherever the trigger pull hits 6 pounds when it moves. Okay, well now things are starting to make sense a little bit. Why did his mom accidentally get shot? And I submit to you, when you're in and out of prisons your whole life, you probably know how to fight. And you're probably pretty good. The next witness that the defense called, Dakota Dunn, the crime scene investigator. She told you that she did the gunshot residue test because she was told to on scene here to see if he was in the immediate area. But we don't have confirmed results for whatever reason of the 2 tests. She said the other test that they did, the gunshot residue doesn't dissipate in time. So now they did that test. They still have the stuff at Margate Police. They knew this trial was coming up. So how hard would it have been to send it over to the lab? Let's run the father for priors. Let's at least tidy up our investigation. No, this is all lack of evidence. The search warrant. She said that 60 to 90 minutes, she was present the whole time. They primarily searched in the kitchen. The house was fairly occluded with things. Did you toss the entire house? No. If something was disheveled, then we would alert the detectives. So if something's hidden and you don't dishevel or put something out of place, if you just have it neatly in there, they don't bother looking. And Junior told you, if they had looked, the gun case that this came in, the Glock case, with a clip, with ammo, was right underneath his bed. We didn't see any pictures of that. I asked her if she did an in-depth search. Well, we were not checking for hiding spots if nothing was disturbed. That's where you check. It's like primarily in the kitchen. No. I asked her, were you searching for another gun? I mean, you guys are taking notes. It's not like... No, we were not searching for another gun. Neither detectives told her to. Okay. Big part of the search, doesn't know anything about the gun. Despite what Senior told the detective in the beginning regarding his wife having a gun. Let's talk about the other detective sergeant that we called, Jared Schwartz. To be honest, I think he's very credible. He said he was with Coben the entire time of the search. I asked him how many people called 911. Don't know. Did you listen to the 911 calls? He said, I didn't. I asked, should they have been saved? Yes. I asked him regarding priors. Did you run junior or senior for priors? Don't know if anyone did. It should have been done. I said, is it normally done before an interview? Yes. He said, even when he was testifying, actually they both did, if you can believe that, 5.5 years, and something that takes literally 5 minutes. It's not like they're working for the 5 minutes, they're just, say, run this guy and wait for teletype 5 minutes to give results. Even now, 5.5 years later, he had no clue whether Senior was a convicted felon. So no one ran in anticipation of this trial. Even after Junior telling them, I'm sure you looked up his record back in the day. I asked him, should it have been done? Yes. Is that something important? Yes. I asked him about the domestic violence charge. He said Coben did the ad charge. I asked him, I'm not going to reiterate all the things that I told you regarding the incident in the car. I said, if you knew that there hadn't been any history of Junior being violent, having any altercations or threats or anything like that with his father, would that have changed? And he said, I don't recall anyone asking Senior about any prior altercations. If in fact there never was, that would corroborate Junior's story. Remember, this elbow was out of the blue. I mean, it's important because it's just the start of lie after lie after lie after lie. And the state is telling you, forget all these things. It doesn't matter because Junior said aggravated. I asked him about the search. He said, I can't say it was thorough. I believe what I did was thorough. Okay, that makes sense. Asked him how long the search was. He wasn't sure. And they only do an inventory if something's removed. So we know that they at least didn't look under the bed. I asked him, let's talk about Senior. Didn't recall him crying at all. I mean, you're not obligated to, but if your wife's dying, I mean, maybe show a little emotion. Did he have any emotion? Didn't see any. Do you see any blood on him? No. Do you know why he went into the apartment after the shooting? No. Do you think that would have been important to know? Yes. He admitted they didn't ask him if Senior put anything in the house. Would that be important? Yes. He admitted that he found it strange that Senior didn't go to Cindy and just to the pocketbook and in the house. It seemed like he should have been more upset than he was. He's thought about it a lot. He was told Senior had a quick temper, was short to anger, would snap, turn into a totally different person. None of this means anything. He admitted that he was told that Senior told him that he had a problem with Cindy taking up for Junior. Stop taking his side. Cindy saying you're too hard on him, and him getting pissed at that. He admitted possession of a firearm by convicted felon, very serious offense. And I asked him, when you inquired, what got Junior so upset that his gun came out? And Senior said, I didn't do anything. There was no confrontation. Senior also said that Junior didn't have any anger issues. Okay? So I'm trying to discredit a witness that isn't here. You have to make a determination of what occurred. So there's a lot of filling in the blanks, and I'm trying my best to do it. Unfortunately, you all are going to have to make a decision and go your whole life without knowing. He said that Junior thought that his father was going to beat his ass. He was afraid for him and his mom. That his mom was not doing well. She didn't need this. That Senior was in his mom's face, and he chest bumped, and he almost said pushed, and he caught himself. It's like when he said, I'm sure you guys looked up his priors, he didn't mean to say that, but he thought that was like automatic that you would do. All to protect Senior. Junior told him that Senior had him totally immobilized. He's ridiculously strong. He tried to push off the wall when he's being pushed against it, and his hand is here with his elbows bent. And then this happens in an instant, literally a few seconds, and the state attorney's office files manslaughter charges against Junior. For a few seconds, we don't even know anything about Senior. Happened in an instant. He said that the angle just didn't make sense. Well, based on what they knew and what they believed, they're taking the three versions that Junior said, and the state's saying, well, he lied. He lied. Yeah, he did. Find him guilty of lying to protect his father. That's okay. We admit that. The angle didn't make sense, and none of the cops could figure out why it didn't make sense. What I told you is the only thing that makes it make sense. I assure you, if I go like that, or up in an angle, your hand's going to, if your hand is on the trigger, you're not going to stop it. So now we have the state telling you Junior shouldn't be upset or get aggravated. We have Senior being really upset with Junior's mom in the vehicle, and his mom like, don't say anything. You're just going to aggravate him more. And that's why they have this nonverbal communication where they can look at the other person and you kind of know what is trying to be gotten across. The state keeps talking about physical altercation, physical abuse. What about mental abuse? We hear a whole lot about that here, how life was like around Senior. Everyone's walking on eggshells. No one can say anything. He's jealous of his wife and his son talking because he thinks they're talking about him or plotting against him. Rest assured, I wish you all, we could have gotten Senior and put him on the witness stand. I guarantee you would have had a good time watching that. Because that's the way that we could ferret out the exact truth of what happened. And then the state, just to add insult to injury, let's tell Junior, we spoke to your dad, we know what happened, own up to it. So now, Junior's thinking, I'm trying to take up for Dad. Obviously, the pinching on my side isn't going anywhere. What did Dad tell the police? Well, he's smart enough to know that Dad didn't tell the police that I pulled a gun on Junior and then he pulled his gun out and I smacked it. He's smart enough to know that Dad's a convicted felon and that if he says that Dad had the gun. That's not going to go over too well. So we spoke to your dad. We know what happened. Own up to it. So then he says that the gun was pushed to the side. He contradicts himself. And the state brings up aggravated again. If you saw your mom getting mistreated and pushed when you have kidney failure on a transplant list because one kidney's at 10%, the other one's at 20 to 30, and she's got stage 4 skin cancer, and you get aggravated because your father is berating and at the very least chest bumping. We know things were bad enough where Cindy Deltoro got in between them behind the car. Well, Junior got in between Senior and Cindy behind the car because of what was going on, seeing his mom get pushed and the yelling and the screaming. We know that Cindy was pushed down in front of that door of the apartment right there. And we know that she came over to the wall to break up Junior and Senior and probably use every ounce of strength she had to push Senior off of Junior. All right, things got to be really bad out there for things to have gotten like this. Now, Senior had never been elbow touched or anything else by Junior in the car. Then we have it followed by Senior calling Junior an ass and pushing him, and for the first time Junior pushes him back. Okay, that's really escalating things. Now we got him ramming Junior up against the wall, and to the point where Cindy Deltoro, in her condition that the state thinks we're faking, to push him off. Okay. Perhaps if Senior had taken the stand and you got to observe him, you could make a judgment call. Things were really bad out there. And then they said, why now did you think to go for your gun? And Junior told him, the way he snapped, yanking me, pulling, pushing, shoving, in the car in my face, in the car with his fist cocked, yelling, slamming the doors, always mean to me. His state of mind is critical as far as what happened. How it happened, obviously. Because how it happened is not a crime. Certainly not against Junior. Why did you do it? Junior says, I just didn't want him on me or hurt my mom. I submit to you, it took a whole lot for him to either push his father or anything. He tells you he's scared of his father. He would never ever think about not not only a physical altercation, but he wouldn't even think about back-talking his father. And then the cops say, you keep skipping over where the gun goes off. One of the most critical aspects of Detective Sergeant Schwartz's testimony. I know you guys are taking good notes, so sure someone's got it in the notes. He said, mistake or not, you're going to be arrested. Actions have consequences. I asked him, Junior said at the scene, my gun went off by accident, and he knew that Cindy had died. And he was honest. He said that's all we needed. So the rest was just window dressing. Everything you saw was window dressing. They were going to charge him based on the fact that it was his gun, he was holding it when it went off, because that's all they needed. He said negligence with a person dying equals manslaughter. He said that. Negligence alone. That's not what Her Honor had read to you, and it's not in the instructions that you're going to get, because negligence alone, even if you find it was negligent, is not enough to constitute culpable negligence. There was no testimony at all regarding anything Junior did that was reckless or a reckless disregard for human life. And Her Honor read to you, and you're going to have it in your instructions, a course of conduct. Course of conduct. That's not a split-second, instantaneous thing. I submit to you, a course of conduct is a little bit more than that. Her Honor read to you, culpable negligence is a conscious indifference to the consequences. I don't think that was shown at all. That it can't be negligent, it's got to be grossly careless, equivalent to an intentional violation. So to him, Junior's state of mind did not matter. It was irrelevant if Junior was scared, if he was immobilized, if he was in fear for him, for his mother. And he didn't say that he pulled it because he wanted to shoot his father. He was trying to scare him. And I submit, if you take a firearm, unless with the type of person his father is, at least if it's not cocked, you're not going to scare this guy. Well, even with it cocked, obviously it didn't scare him. Everyone is scared of him for a reason. He has a reputation for violence. It's not... When you have a reputation for violence, you're not talking about that's what I think. You're talking about that's what the community thinks. Whether it's the community of all his family and all the workers and all the neighbors, basically whoever knows him, they're not going to mess with him. They know he's violent and...
Objection, Your Honor, misstating the law.
Sistine.
The detectives had to say at least 10 or 12 times, we don't think it was intentional. We don't think it was intentional. We know it was an accident. We don't debate the accidental discharge. We don't debate the accidental discharge. And then say, mistake or not, actions have consequences. You're being arrested. And they said, do you have any questions? He didn't have any questions about himself. 2 words he said. My dad. Like a question, right? And they didn't put anything together. I'm sure no one did, unless you know what occurred. And then as a follow-up, they were telling him to take off his jewelry and put it in the bag. And he says, can my dad take it? His dad in the clear. Did I do what Mom wanted me to do? So, Her Honor told you that the burden of proof in this case is on the state, beyond and to the exclusion of every reasonable doubt. But it was us that called the second detective. It was us that called the crime scene investigator. It was us that called the other firearms expert. And it's us that tried to find Dad. But the state made it appear to you like the burden was on us, when the burden is on them. But rest assured, we tried everything we could to get them find them. And the state went to great lengths to make it like, well, we didn't find any pair of glasses. We didn't find any chains. Like this is the missing thing to the whole case. Of course they didn't find them. Senior hid the glasses, the gun, the chains. So how are they going to take a picture of something that they don't see? And if you think about it, of all the things that Junior can lie about, why would he lie about his glasses being broken off? I mean, you see the blood running down his face. You see the broken pair of glasses. But the state wants you to believe that that was blowback from blood from his mom being shot. But they don't look at the white shirt he's wearing and the fact that there's... How do you... Now, I can understand someone getting shot and you're close by and you get some blood on you, but it's not going to be one little speck that runs down your face. That just defies common sense. So this case boils down to what led up to basically 10 seconds in time in his entire life, and the state charges him with manslaughter. And the prosecutor tells you, well, we didn't charge him with murder 1, and we didn't charge him with murder 2. So we gave him a break. Now, you guys just come back with manslaughter. You guys live with making that decision. Regarding the gunshot residue, the state was arguing, well, we don't know if Senior cleaned his hands, because we don't know if there was a false positive. We don't know how long the nitrates stay on the hand, and there's a possibility of transference, oh my God, if you're going to argue all that stuff, just confirm whatever results you had. And the weird part about this is, these are things that the defense normally argues, not the prosecution. It's the defense that would normally argue, well, there could be a false positive, right? How the nitrates don't stay on there that long. It could be transference. We're not making that argument. They are. The state of Florida, there's no duty to retreat. But I made sure that I asked Junior, is there any way possible that you could have gotten away from your dad with your mom safely? No, that was not going to happen. He didn't have the keys to his car. His mom's already been battered. He's afraid like crazy. How's he going to plan an escape route to bring his mom to safety, and he doesn't even have his keys? It's the state's burden to disprove self-defense, also beyond and to the exclusion of every reasonable doubt. So, as I said, Detective Schwartz, I mean, we can't unring that bell, even though the state tried, right at the end. Negligence plus death equals manslaughter. No, it does not. His gun fired, a death resulted, manslaughter. And I made sure that I asked him a number of different ways, because I know that you guys are taking notes, and I want, or hoping that that's being taken down. Does being scared, intimidated, rage, snapping, does any of that matter? No. What about attacking his wife, being in her face, yelling at her, pushing her? No. This is not a beyond a reasonable doubt case. I mean, if we can take someone's freedom and liberty away because he said aggravated about 10 or 12 times a couple hours after an incident where he's got all these things going through his mind, he never talked to a cop in his life, that's some pretty... That would be a really bad justice system if that's all it takes to convict someone and take his freedom and liberty away from him. Think of all the evidence the state has. Take away his statement, they have zero. A scared kid on his birthday watching his mom get pummeled, verbally, physically, being scared to death of his father, and we're going to take a snapshot of 10 seconds in time. Let's forget everything else around that, and the state wants you to convict him. They don't have to live with this. You all are going to have to live with it. I submit to you that Junior was just going by his mother's wishes. If mom survives, she's going to be upset if dad's not around. If mom doesn't survive, She wanted me to do anything and everything I could do to protect him. Obviously, this wasn't in the scenario of anything that she was thinking, but that's what's in his mind. A scared 28-year-old on his birthday. So, what this case boils down to, a scared kid on his birthday tried to save his mother from his father. Then he tried to save his father for his mother. And now he's counting on you all to live up to your responsibility of holding the state to prove him guilty beyond and to the exclusion of every reasonable doubt. And I was so glad that the prosecutor read all these instructions. I honestly was, because it just reinforced everything that I want to say, and that saved me the time. So I was actually going to go through it all. Only not guilty. And remember, if you want to get technical, substitute the word for proven for guilty. Did the state prove him guilty beyond and to the exclusion of every reasonable doubt, or was it not proven? Proven, not proven. You don't hear innocence anywhere, even though I believe it. Junior has not even been able to begin to truly grieve for his mother. He's only a shell of the person that he once was. He used to
Objection, Your Honor. Sympathy.
Sustained.
He has lost so much here. Lost his mother, his father's nowhere around. 5.5 years. The state keeps bringing up like it was us that caused it to be 5.5 years. 5.5 years they had to think about what happened and create this self-defense. 5.5 years they took to do this. We didn't do COVID. We don't control the dockets. Remember, COVID was right in the middle of this. You can think of the 5.5 years of what Junior has had to go through and anticipate and dread listening to what we're talking about right now.
Objection, Your Honor. Sympathy.
Sustained.
So, justifiable homicide. Resisting an attempt for the senior to commit a forcible felony, whether it be attempted murder or even aggravated assault, is a forcible felony. And you'll see that in the jury instructions. If you think that this resulted from even an aggravated assault, then that's justifiable homicide. If you read the definition of excusable homicide, if this was an accident and misfortune in him doing a lawful act by lawful means without any unlawful intent, then it's excusable. The state would have you believe you don't even have a right to defend yourself in Florida. Culpable negligence. In the instructions, Was this gross and flagrant? Did this exhibit a course of conduct showing reckless disregard for human life? Did the state prove wantonness or recklessness? Did they prove a conscious indifference to the consequences? And was this the equivalent to an intentional violation? The definition of negligence is extremely important. We all have a duty to act reasonably towards others. And a violation without any intent to harm is not criminal. The self-defense. You have an instruction on that. You're allowed to use deadly force, even though he wasn't doing it, if he reasonably believed it was necessary to prevent death or great bodily harm to himself or another. And when we started out, at some point we talked about protecting individuals' rights and liberties. And we talked about not depriving Junior of his liberty and freedom without overwhelming proof of criminal misconduct. The state must have an airtight case that convictions should only be from indisputable evidence. Like I said, this is a horrible tragedy. It's like a Shakespeare. He's trying to save his mother from his father, and then he tried to save his father because of his mother, or for his mother. Please end this nightmare and find him not guilty. Thank you.
All right, ladies and gentlemen. I'm going to try to make this quick. I know it's been a long day. This, once again, this is Main Street. These elements to this crime that the defendant is charged with, manslaughter with the firearm, this is Main Street. To prove the crime of manslaughter, the state must prove the following two elements. Cindy died, and the defendant intentionally committed an act or acts that caused the death of Cindy, or the death of Cindy was caused by culpable negligence of the defendant. So either he intentionally committed the act or culpable negligence. It's going to stay up there. It is what it is. It's been a long day. To keep you on Main Street, because I know defense just mentioned a lot. To keep you on Main Street, in addition to those elements, it is the definition of culpable negligence, which states, once again, that in order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such of an entire want of care as to raise a presumption of a conscious indifference to the consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. This is Main Street. So you have the one option, culpable negligence, or the intentional act committed by the defendant which caused the death of Cindy, which is where the transferred intent comes in. This is not, as defense counsel stated, a scared kid on his birthday. This is a kid who, hours after this happened, is given a statement to detectives and laughed multiple times throughout that statement. You'll have it back there to take back with you. I don't want to waste more time by playing the statement. laughed multiple times in that statement, talking about what happened to his mother. Defense counsel spoke about how the state said it's not murder 1 or murder 2, so let's give him a break with manslaughter. That's not what's happening here. What's happening here is he's charged with manslaughter with a firearm because he committed manslaughter with a firearm. Representing the state of Florida, representing the people of the state of Florida, we have the responsibility to not overcharge. To not say it's not, let's charge him with murder 1 or murder 2 and give him a break and you guys come back with manslaughter. It does not work that way in this country. He is charged with manslaughter with the firearm because he committed manslaughter with a firearm. And defense counsel had you going down all these side streets, or as he referred to it, window dressing. All of these side streets. The same thing with the defendant's testimony while he was up here for 2 days. All these side streets. Talking about all these different things to avoid Main Street, to avoid what happened with that firearm that struck his mother in the head. The dad's reaction. Everyone reacts to trauma differently. The lack of evidence for gunshot residue results, or collection of clothes, or lost 911 calls, or running cars. To show what? To show what? Because in both of defendant's statements, his dad was there. He was there. So it's going to show you what? There's nothing additional that you're going to gain from this stuff. Same thing that there's nothing additional in a witness being called where another witness did everything that they did as well. It's going down side streets. It's having you go down a side street so that you're not focused on the main street of manslaughter with a firearm, the charge in this case. Defense counsel said there's nothing else besides the defendant and his dad's statement. What do you call all of this? What do you call the other witnesses who came in to testify? That's something else. It is not just the statement of one person that puts us here today. Otherwise, all that would have been played is the statement of one person. More side streets. A second charge of domestic violence battery that we're not here for, that the defendant is not charged with, but that's another side street. Look at this charge so that you're not looking at this charge. Go down a side street so that you get off of Main Street. The search of the home. In the testimony, it came out there were hundreds of photos of this home. Some of them are back there so that you don't have duplicates and duplicates, but there's photos that you can look at. They searched everywhere. They searched under beds. They took out boxes. They opened boxes. They searched in backpacks. They searched in more than just the front kitchen inside of a purse. It's right there. Defense counsel also got up here and said that the defendant didn't know what happened to his mom until the cops told him. Now, I know that everyone handles trauma differently. But to say that the defendant didn't know that his mom was already deceased on scene when taking everything in its totality just doesn't add up. What we have in the evidence is that he was hysterically crying on scene. It's that his mom was pronounced deceased on scene. She was shot in the middle of her head. She was unresponsive. But when he's told hours later in the interview room that his mom had passed away from this, he doesn't cry. He doesn't yell out and scream. It's because he already knew. But that is just an argument being made for you to garner sympathy, which I went over is not something for you to consider when rendering a verdict. You all were chosen because you said you could be unsympathetic jurors. You could be unbiased jurors. You can follow the law of this country that we all share. So you are to not consider sympathy and arguments that are made to you for sympathy purposes alone. Defense counsel spoke about the discharge of the firearm and how the firearm was discharged because it thought it was hit. Now in this firearm, it's not as dramatic as over here, but this is the trigger lock. This is where it is. This is what prevents a firearm from just thinking that it's being hit. The trigger has to be pulled to release that trigger lock. And that is what was done in this case. There's all the evidence in this case that points to that this gun did not just pop. This gun was not thrown on the floor and went off. This gun did not go off on its own. That trigger was pulled with 6 pounds of pressure, whether you want to believe his version that it was smacked when his finger was on the trigger and pulled it, or when he tossed it, his finger was on the trigger and pulled it. But regardless, the act of introducing that firearm to an altercation that did not involve that level, if at all, any violence, is what is the culpable negligence in this case. Taking out a firearm and bringing that deadly force when other people are around and having the dangerous effects, showing the reckless disregard of human life or the safety of persons, the indifference to consequences, the wantonness or recklessness or grossly careless disregard for the safety and welfare of public on Main Street. Either way you want to believe his version, that gun is not going off without his finger on the trigger, pulling that 6 pounds, and that bullet exiting that he knew was in there and entering his mom's face. That is Main Street. That is why we are here today. That is why he is charged with manslaughter with a firearm. He also wants you to think that the gun just went off. We heard from multiple witnesses, from the lieutenant in this case, from the firearms guy in this case, the #1 gun safety rule is you do not put your finger on the trigger unless and until you're ready to shoot, and they even said you shoot to destroy. That is the testimony in this case. That goes towards Main Street. That goes to why we are here today. And if we want to believe the version that he has today, which is that he racked that gun to fear his dad, then there would have been another casing on the floor. Another bullet would have left that firearm, but there was only one. There was only the one that he shot out of that firearm and hit his mother in the face. That's because the version of the racking is made up. Because those 5 years that he had to think about it is just another thing that he made up. And that's the state's position for talking about the 5-year time difference. Not the fact that it was delayed by any part of anyone, because that's just how the justice system works sometimes. But the fact that he had 5 years to make up this stuff and it still is flawed and inconsistent just further shows that it's made up. And that's why it doesn't add up. He didn't rack that firearm like he says he did to put his dad in fear. He took that firearm out and shot it. Same way I would never say that somebody did not have a sickness that they had. I am not saying that Cindy did not have cancer, did not have to deal with her kidney. What I'm saying is that that version doesn't make sense, because if there was this frail woman that I do believe she was frail from her kidney condition, then she wouldn't have been able to get up after just being shoved down and go and shove a man that the defendant said was too strong for him to move. It's made up. It doesn't add up. That is the state's point of telling you how he had the 5 years to come up with this, and it still doesn't make sense because it is nonsense. That was the point of telling you all of that. We heard from Dr. Robinson there were no bruises on Cindy's body. There were no cuts on Cindy's body. There were no broken bones. Other than the injury from the gunshot wound to her head, there were no other injuries on her body. Now, just briefly, because I know I went over it and defense counsel went over it, but the differences between the justifiable homicide and the excusable homicide, defense counsel once again brought up accident and the existence of an accident. An accident is not what we have here. Accidentally shooting your mom when you meant to either scare, intimidate, or shoot your dad is not the type of accident that allows for excusable homicide or justifiable homicide. An example of that would be if a dad was with his adult son, and his dad was cleaning out his gun. And he's an experienced gun owner, and he looks and he doesn't think anything is in the barrel after he checks, and he's cleaning out the gun and he's showing his son how to take the gun apart, and then that gun goes off. Even though he had checked it, even though he has had guns, even though it was not his, that was an accident. That is an accident. An accident is not taking out your firearm to scare or intimidate somebody else or shoot somebody else and then getting another person. That is not an accident that is excused by the law. And defense counsel said that the state is arguing you don't have a right to defend yourself in Florida. Well, the law is there. But the law says you do not have a right to defend yourself with deadly force because your feelings are hurt. You don't have the right to defend yourself with deadly force because somebody else was shoved or you were shoved. You don't even have a right to defend yourself with deadly force if you think someone has a gun or if you see a gun. You have to think that there is deadly force. There has to actually be deadly force to match it with deadly force.
It's a misstatement of...
Sustained. Sustained.
And that's what we have in this case. We have somebody who took out a gun because he guessed there was a gun, if you believe that version, or took out a gun because his feelings were hurt, or took out a gun because somebody was pushed, or took out a gun because he was pinned up against the wall. None of that is excusable. None of that allows you to take out a gun, a loaded gun, put your finger on the trigger in this case, or in any case. And defense counsel brought up how the self-defense burden is still on the state, and it is still on the state. We are the ones who have the burden in this case to prove this crime and for you to not fall under the story that it was self-defense. And in that jury instruction that I went through with you, there's a part that says the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary, which is what I was just talking about. So real. Not an assumption, not an I think, not a guess, not a my glasses aren't on so I can't really see. So real. And it further says it's a reasonably cautious and prudent person standard. Let's go back to Main Street. Taking out a loaded firearm, putting your finger on the trigger, that is not a reasonably cautious and prudent person standard being met. In furtherance, it says that if you find that the defendant who, because of prior threats or difficulty with with his dad, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of his dad. Prior threats. He had to have these prior threats, which once again brings us back to the 5 years that he had to come up with this testimony that still doesn't add up.
Objection. He doesn't.
Legal objection, please.
Misstatement of the law.
Overruled.
That is the purpose for all of that. That is why the state went into that. Further and said, committed an act or acts of violence. Originally, he tells the cops his dad is not violent, and then all of a sudden, today, his dad is the most violent. His dad is controlling, manipulative, too many guns to count, in and out of prison. This all goes to credibility. This goes to listening to the evidence and determining the credibility of what is said to you. And that's why I highlighted that this came out 5 years later. And that's why I highlighted that he is the one with the most interest in the case. He is the one that has the most interest to now come in and say all of this stuff, even though it has never been said before. That instruction further states that if Alexander Deltoro Sr. had a reputation of being violent and dangerous, and his reputation was known to Alexander Deltoro Jr. So nothing about the community, nothing about the family, nothing about anyone else. It has to be known to him for his state of mind. He told the police that night his dad was never violent. His dad didn't hit him since he was being disciplined as a kid, so since he was an adult. His dad did not hit his mom. His dad was a changed person. In his statement, his past was from 28 to 30 years ago, which is now close to 35 years ago. Only in trial now is his dad's reputation to him all of a sudden the most big, bad, violent, scary person that's ever existed. This is a side street. That is the state's purpose for highlighting it, to keep you on Main Street and not focused on these side streets. Defense counsel spoke about how the state has no clue why and how the defendant did this. Well, it's obvious how this happened, I would submit to you, because we have the firearm, we have the casing, we have the defendant's own words, we have the fact that he accidentally shot his mom, is what he told law enforcement when they arrived. We have the reenactment. We have the fact that there's no other firearms, no other casings. We have the testimony that the projectile in her head matches. It all is consistent. It all corroborates each other. That the defendant's firearm that he was holding when he pulled the trigger is the reason why his mom is not here today. That is the how. And the why, that for why we're here today is the instruction. Main Street. That's why we're here. Because he took out a gun during a verbal argument. He took out a loaded firearm because somebody was shoved. He took out a loaded firearm and put his finger on the trigger because he was pinned against the wall and got his feelings hurt. He took out a loaded firearm, put his finger on the trigger, and pointed it at his dad because he thought that his dad pulled something out of his pocket that he couldn't see without his glasses. Defense counsel said that the defendant lied back then because he did not want his mom to be mad at him if his dad ended up in prison. So let's look at those two options. The first option is that his mom survived, because he said at that point he didn't know if his mom survived. So now his mom survived, and there's a controlling, manipulative, drug-stealing, emotionally abusive husband, who in this instance now became physically abusive, who did all of this to her and has been this way her whole life according to him, and she survived in this scenario, so she knows what happened that day. And in that scenario, he would have been defending her, and she was aware of that. Why would she be mad? It doesn't make sense. Why would she be mad? She wouldn't be mad. If her son was actually defending her from this crazy man, and she survived, she would have been thankful, not mad that her husband, who's this awful man, is in prison. And then we have the other option where she didn't make it. So he says he has to protect his dad, who he tells you is a lowlife, who doesn't work, who doesn't pay bills, who sucks, who's controlling, who's manipulative, who has this scary past, who's emotionally abusive, who now turned physically abusive. He testifies he's able to live on his own, he has his own car, he has his own house, he works, he pays his own bills. That version doesn't make sense either. He has family who supports him. He has family who comes in and testifies to outrageous things for him. That version doesn't make sense either, because that version is not what happened. It does not make sense because that is nonsense. And that is what is being said to you. And so much of what is being said to you is either being said for that reason, to go down a side street and stay away from Main Street, or is being said to you for sympathy, for you to worry about taking away his life and liberty. This man who's been walking around since a month after this incident. And that's not for you to consider, because we went over that. It says your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. That's the instruction in the rules for deliberation that the judge is going to read to you very shortly.
Do you have an objection?
I would just like to approach real quick.
Do you have an objection?
The time.
Another time. Let her finish. Thank you.
5 minutes, not even.
Go ahead.
That is the instruction that is about to be read to you. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Your duty is to say if we did our job. What I spoke to you about in jury selection. If we have proven this case to you, if we have presented credible evidence to you, if we have kept you on Main Street and fulfilled these elements, that's your duty. To say if the defendant has been proven guilty or not in accord with the law. It's the judge's duty to determine a proper sentence if the defendant is found guilty. That means that that's not something for you to consider in this case. So think about why these arguments are being made to you. Think about why these arguments keep you away from Main Street. And defense counsel spoke about a reasonable doubt as to the guilt of evidence may arise from the evidence, conflict in the evidence, and the lack of evidence. And they want you to consider different things as a lack of evidence, such as no 911 call, no GSR results, no priors. I said this in the beginning, and I'm just going to remind you all. A reasonable doubt, it says right here, a reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. And you are the one who is going to find if the defendant is not guilty or guilty, and you are the one who is going to decide that based on what evidence you decide is credible. But it's important because it states a reasonable doubt as a guilt to the defendants, as a guilt to the defendant, meaning these elements, meaning Main Street. Nowhere on here does it say there needs to be a 911 call of the defendant crying. Nowhere on here does it need to say that there's gunshot residue results or not gunshot residue results. That's going to say that the defendant's dad was right there, which is what everyone's agreeing to. The defendant's dad was right there. He tried to shoot his dad or intimidate his dad, and he got his mom. Ladies and gentlemen, I ask that when you take all of this evidence and you consider this evidence and you apply the law to the evidence that you have, that you return that verdict of guilty of manslaughter with a firearm because the defendant is guilty of manslaughter with a firearm. Thank you.